Hello, I'm from the law offices of Miles Mason. Today we have another installment in our favorite series, Cheating Wife's Day in Court. This is episode number 3. And it is not very often that we get to see these things happen in court. But if you recall in episode 1, we talked about a woman who was being exposed for cheating on her husband. And she was so brazen that she actually tried to recruit her friend to testify falsely on her behalf in court. Unfortunately, that friend saw the light and ended up testifying truthfully against this horrible woman. And that's exactly what happened here. So let's go ahead and dive right into this one. You're watching Cheating Wife's Day in Court, episode number 3. We've got another good one for you today, so please remember to like and subscribe. Okay, now in today's video, I've said it before, and I'll say it again. If you know the rules of evidence, it can be an absolute gold mine for you in your case. Now, if you don't know the rules of evidence, well, you might just end up looking like a fool in court, which is exactly what happens in this video. Now, the reason why I love these videos is because oftentimes people will say, "Oh, why do you have to be so mean? Why are you attacking people?" And the reason why I'm attacking people in these videos is because they're re-attacking themselves by doing stupid stuff, and I'm merely pointing it out. That's all I'm doing. I'm not making stuff up. They're literally destroying themselves through their own actions. And this video is no different. This is an absolute goldmine for the husband in this case. So let's go ahead and dive into it. Hi there. I'm a board-certified civil trial attorney. I'm from a law firm in San Diego, California. It's my job to take highly contested custody cases to trial. That's what we do every day in court. And I want to show you some of the things that I see happen in court, both good and bad. In this video, I want to talk about something very important. I want to talk about a situation where a client came to me after he had been through a divorce, and he wanted to appeal the custody order that had been entered in his case. Now, it wasn't really a custody order per se. It was more of a judgment of dissolution, a divorce. But there were children involved. And at the end of the day, he was getting less custody of his kids than he thought he should get. And so he tells me, "I've got this situation. I want to appeal it." And then he tells me about something that happened during the trial that he wants to appeal. He says, "The judge allowed my ex-wife to call her friend, her so-called friend, to testify about a conversation that she had with my son. And basically, her friend said that my son told this other woman that he preferred to live with mom. And this woman gave all this testimony about how she was such a great mom and how my son loved her so much and how my son would always come running over to her house and all these types of things." And he said that shouldn't have been allowed. The judge made a mistake by allowing this testimony, and so he wanted to appeal that part of the judgment. And when I heard this, I said, "You know what? You've got a great appeal. It sounds like the judge made a mistake." So we took the case on appeal. Now, if you watched the first 2 episodes of Cheating Wife's Day in Court, you probably know that the appellate court reviews the case based on the cold, hard, legal rules of evidence. And if something isn't done correctly down below in the trial court, it must be done correctly on appeal. One of the most basic rules of evidence is the hearsay rule. Hearsay is an out-of-court statement offered to prove the truth of the matter asserted. In other words, if someone testifies in court about something that someone else said outside of court, that's hearsay. If it's being offered to prove the truth of what that person said. Let us go ahead and look at the definition of hearsay as set forth in the California Evidence Code. A hearsay statement is an out-of-court statement. That is a statement made outside of court, offered in evidence to prove in some way the truth of the fact that it asserted. For example, if a witness testifies at trial that he heard the defendant admit to the crime, that would be hearsay because the prosecution is trying to prove the truth of what the defendant allegedly said. If the witness could testify as to what the defendant actually said, that would not be hearsay. That would be an actual statement of fact. In addition to the basic definition of hearsay, there's also an exception to the hearsay rule called the present sense impression exception. The present sense impression exception to the hearsay rule allows for the admission of a statement describing or explaining an event or condition made while the declarant was perceiving the event or condition or immediately thereafter. Let's go ahead and apply those rules to this case. The husband says that the judge erred by allowing the wife as friend to testify about statements that the child made to her about living arrangements. Let's go ahead and analyze this situation under the rules of evidence. The statement that the child made to the friend was clearly an out-of-court statement. That's number 1. No. 2. 2. The wife's friend testified about the statement in court. That's no. 3. And non quattro, the wife's friend testified about the statement to prove the truth of the matter asserted, i.e., to prove that the child really did say that he preferred to live with mom. All 4 elements of hearsay are present in this scenario. However, does this testimony fall within any exception to the hearsay rule? The only possible exception that could apply here is the present sense impression exception. This exception only applies if the statement was made while the child was perceiving the event or condition or immediately thereafter. Did the child make the statement to the friend while he was perceiving the event or condition of whether he wanted to live with mom or dad? Of course not. The child had already made up his mind about where he wanted to live, and there is no indication that the child was making the statement to the friend while he was experiencing something or perceiving something. Therefore, the present sense impression exception does not apply. As a result of this, the only thing that the wife's friend could testify to is that the child told her that he preferred to live with mom. Any other testimony about how wonderful the mother was, or how much the child loved the mother, or anything along those lines would be pure speculation and conjecture on the part of the friend, and therefore, it would be inadmissible. Once we established that the judge erred by admitting this hearsay testimony, the next question was whether the admission of the hearsay evidence resulted in a miscarriage of justice. In other words, did the judge's error result in a denial of the husband's right to due process? The answer in this case was yes. The reason why the admission of the hearsay evidence was prejudicial to the husband is because it directly resulted in the trier of fact having additional evidence to base his decision on. In other words, the judge heard evidence that he shouldn't have heard, and that caused him to make an erroneous decision. Here's a copy of the decision that was filed in this case. It says, "The judgment is reversed as to custody and visitation. The Superior Court is ordered to enter a new judgment consistent with this opinion. Each party is to bear his or her own costs on appeal." In other words, the appellate court completely overturned the custody portion of the divorce decree. Because the judge allowed inadmissible evidence at the trial level, now, keep in mind that the appellate court is not going to get involved in every little evidentiary issue. Generally, the appellate court will only reverse a trial court's rulings if the party who objected to the evidence can show that the erroneous admission of the evidence resulted in a miscarriage of justice. In this case, the husband was able to show that the erroneous admission of the hearsay testimony resulted in a miscarriage of justice because the hearsay testimony was so prejudicial to his case. If you'd like to learn more about the rules of evidence or watch other installments of Cheating Wife's Day in Court, click the link above.